series of books that are being published by the Law and Society Research Unit at the American University in Cairo. They're collecting judicial decisions from Majlis al-Dawla, which is the Egyptian Council of State, or the Egyptian State Council, published in the last, or issued by the court from 2008 to 2018. They're publishing these in Arabic, and then they also have me translating them into English to be published as an English volume. And so this experience is what will be the object of study in my talk. And I've been working on it for the past 2 years, and I've thought about, over that course of time, the famous epigraph that Edward Said used to open Orientalism, which was, "They cannot represent themselves, they must be represented." And of course, Said was talking about European Orientalists in the 19th century representing, describing, analyzing, and generalizing about what they would have called the Orient. But in the context of translation, I've found that this epigraph takes on a paradoxical significance, because translators, in a way, are trapped in the role of representing. It's the translator's job to represent the original text in the target language. And it's not necessarily about the self and the other. I mean, sometimes you can translate your own text into another language. In the case of Samuel Beckett, he wrote Waiting for Godot in French and then translated it back into his native language. So it's not about the self and the other. It's about translating one thing into another and trying to come up with something that feels like or gives the illusion of being the same or fundamentally somehow a fair representation of the original in the target language. And the analogy that I've come up with, or that I want to propose, is that translation is very much like a lens. It's a lens that is between the target language and the original language, or between the audience of the target language and the original language. And its purpose, of course, is to increase the visibility of the original text, or the original language. However, like as with any lens, there's always the problem of distortion. Lens can blur just as well as it can help you see. And on either side of the zone where it's in focus, if you set up the lens too short, you're actually not going to be helping your audience see the original text. You'll be giving them a blurred image. If you set it up too long, you'll have the same problem, a blurred image of the original. And it's only when you find the right spot in the middle that you can really bring the text into focus for the new audience. This reminds me of what Professor Salam Akar yesterday called the illusion of transparency, because in this scenario, where the lens is actually blurring the text, the audience is likely to feel that they're seeing, that's what it is, and it's just blurry. It's a terrible text. What's wrong with it? But they have the illusion of seeing it that way. And Professor Al-Wazna also yesterday gave us a great description of the concepts of foreignizing and domesticating, which I think, at least for me, is the framework for understanding these two extremes of the lens being too long or the lens being too short. Foreignizing, according to Lawrence Venuti, describes efforts by the translator to restore or preserve the foreignness of the foreign text. In the translation, a foreignizing translation will leave the audience of the target language text feeling that the original must have been quite strange, different, exotic, other. Whereas domesticating is the process by which a text is inscribed with domestic intelligibilities and interests. In other words, it's made to feel recognizable, normal, something that might as well have been written in the original in my target language. So I'd like to give 2 examples from these translations that I've done of both foreignizing and domesticating translations, and how I walked through them and what I finally wound up deciding to do. And the first one that I'll come to is Da'wa al-Ilgha. So these decisions from Majlis al-Dawla are in the field of Egyptian administrative law. And administrative law in Egypt covers pretty much any dispute with the government. A lot of these cases involve plaintiffs challenging government action as contrary to law and therefore null and void. So it's the most common form of lawsuit in these courts is da'wa al-ilgha. So I was confronted with the issue of how to translate this term. And I hope you'll indulge me to come up with the most foreignizing translation possible. I would like to call for some help from beyond the grave or deep in the stacks of the British Library or maybe in one of the storage rooms at the British Museum from a dusty 19th century Orientalist. Let's call him the far-sighted Orientalist, because he can only see things that are very far away, that are very different, and do not in any way resemble what's nearby and familiar and part of his own cultural context. So if this far-sighted Orientalist were asked to translate da'wa al-ilgha, he might leave the term untranslated and transliterate it in italics, like this, and possibly he would provide a translator's note using his far-sighted Orientalist expertise, perhaps saying something like this: Da'wa al-ilgha is a unique feature of the law of Egypt, which gives Egyptians a limited ability to petition what they call their majlis for relief from excessively despotic government conduct. Or he might take another route, which would be another foreignizing option from the far-sighted Orientalist, would be perhaps to use flowery and antiquated language, calling it a prayer for cancellation or to make as naught. Now, using this kind of translation for judicial decisions published in the last, or issued by the court in the last 10 years in the context of civil rights, property law, constitutional law, honestly, I think it would be somewhat ridiculous. These kinds of lawsuits and the judicial decisions deciding them are absolutely familiar to any American lawyer, British lawyer, probably lawyers all around the entire world today. And to use this kind of foreignizing translation would basically leave it obscured under a cloud of mystery, otherness, and exoticism. So that's foreignizing. But there's a problem that you can reach on the other side of the spectrum. If you, instead of the far-sighted Orientalist, you called in the excessive domesticator, who just had a mania for finding exactly the equivalent in the legal system of the target language that's no different from the legal system of the original language, and this excessive domesticator happened to be from New York, he might say, well, under the law of New York, there happens to be a kind of lawsuit in which you can challenge government action as contrary to law and get the court to hold that the government's conduct is null and void. This is called an Article 78 proceeding in New York. Translating da'wa al-ilgha as an Article 78 proceeding would also be ridiculous, I think. There are some other U.S. law names for lawsuits that challenge government action, all of which are just quite specific. And really, if you were to take the logic of this approach, the excessive domesticating approach, to its ultimate logical conclusion, you would wind up translating Al-Qahira as Albany, because Albany is the capital of New York, or Al-Qahira as Washington, because that's the capital of the United States. So there's dangers on both sides. So to bring the translation into clear focus, I wound up going with annulment suit. Annulment suit is a term which says what this lawsuit is and what it does. It can feel recognizable to an English language audience without being identical. But it allows for the fact that this concept, da'wa al-ilgha, is part of a legal system that is indeed different, but without being exotic. We can find, in this way, I hope, a happy medium in the middle, where the lens is focused just right to bring this feature of Egyptian law into relief. And so my lessons from this first example are that a good translation should recognize commonality while also admitting the impossibility of direct one-to-one translation. So far, I think everything I've said could apply just as well to translating literature or any other genre of text. But law is not literature, in my view. As a lawyer, I look at legal texts of any kind, whether they're contracts or constitutions or statutes, as functional instruments that perform a role in a specialized system. And they should be judged according to the standards of that system. Unlike literary texts in which ambiguity is often a virtue, legal documents purport to assign uniform, agreed-upon meanings to the technical words and phrases of legal discourse. And even in a monolingual context, of course, uniform, definite meaning is impossible. It's not ever fully achieved. Without any translation of law coming into the picture, lawsuits happen because people disagree about what a contract means. It's something that is a par for the course when legal ideals meet the messiness of reality. But even if semantic uniformity is an ideal more than a reality, it is an ideal towards which legal texts are constantly striving. And that's one of the standards by which the technical system of law should be measured. So, given this context, domesticating and foreignizing takes on there's another dimension on which to measure the success or failure of the translation. So, this next example, Zawaj al-Arfi, might be familiar to many of you. It's my understanding from talking with Egyptian lawyers and actually someone I know who has been in Zawaj al-Arfi, is that it's marriage without involvement of or notification to any state office or agency. And if there's a later dispute about the marriage, this can lead to complications. And we have two decisions from Majlis Adala that we're publishing in which the paternity and nationality of the children were called into question. And Majlis Adala was called upon to decide legal issues relating to this marriage. Now, a simple and literal, sort of neutral translation of Zawaj al-Arfi, I think, might be customary marriage. From an aesthetic and political perspective, it's quite effective. It neither exoticizes this form of marriage to the point of alienating the audience from the original authors and their subject matter, nor does it displace the original cultural institution by imposing some arguably analogous U.S. equivalent, like Article 78 proceeding, or the other examples I came up with for the excessively domesticating side. So superficially, it seems at first blush to be just as successful as annulment suit. But technically speaking, I'll get to that in a second. Technically speaking, if someone doesn't know what a Zawaj al-Arfi is, and they're reading an English language text, translating an Egyptian court decision, and then they get to the phrase customary marriage, well, they'll think, what could that be? It must be a marriage that complies with Egyptian customs. All customs relating to marriage, whether the age of the people getting married, consent, gender, previous marriages and divorces. In other words, a lawful marriage. And that would include marriages that are contracted with the assistance of the state or through formal legal channels of the state, which is, of course, exactly the opposite of a Zawaj al-Arfi. So the goal then became to find the technical legal significance. And I feel that legal terms are not able ever to convey the entire body of law that they're related to. All the definitions and requirements, either in statute or in court decisions about a given legal concept, but legal terms should at least point in the direction of that body of law. And my image for this that I always think of is al-ful al-nabit. Does anyone here know al-ful al-nabit? There's a little sprout coming out of the center of the fool, that's the nebet. And so if you have a bean, that's like the entire corpus of law relating to some issue. And the phrase that you come up with, there should at least be a little finger indicating so that the reader or the lawyer or the party, the citizen, whoever is called upon to interact with this legal phrase should know that it's pointing to this body of law and have an idea of where it's going. Now, to try to convey the relevant core of this concept, I decided to go farther down the domesticating end of the spectrum. And I experimented for a while with calling it a common law marriage. So the virtue of using this alternative is that common law marriage is a recognizable legal concept from Anglo-American legal culture, which relates specifically to this issue of whether the marriage was contracted through formal legal channels. In both the Anglo-American institution of common law marriage and the Egyptian institution of az-zawaj al-urfi, a real and acknowledged marriage comes into existence, but it happens without going through formal legal channels. But there are problems with this, because common law marriage is retrospective. It's formed when the couple has already been cohabitating for several years. It's basically a subsequent ratification of their relationship. Whereas az-zawaj al-urfi is a prospective agreement that the couple is going to be married from now on. Also, az-zawaj al-urfi is a contract. It's written out. Whereas common law marriage is something that courts will deem the couple to have entered into after enough years have passed. So there's no written agreement in a common law marriage, which became incongruous in several places in these judicial decisions where the court would refer to Oct Zawaj al-Urfi, and if I were using common law marriage, you would wind up with these English sentences referring to the common law marriage contract, so it just broke down as a translation. And I have some nostalgia for the common law marriage phase of this translation because it was sort of a cute solution to the problem of how to communicate the legally relevant technical core of this idea. But as you can see, it ultimately didn't work. And the reasons it didn't work were technical legal reasons, not aesthetic or political reasons. So our friend Ahmad Shalani, who unfortunately can't be here today, is actually the one who helped me come up with the solution here, which was instead to call az-zawaj al-urfi unregistered marriage, because this phrase points to the technical legal core of the concept. The fact that these marriages are not registered with the state is what makes them legally complicated for the Egyptian administrative courts in the particular decisions that we're publishing. But this fact was missing from the direct literal translation of customary marriage and was completely obscured or reversed in some ways with the more domesticating translation of common law marriage. How much time do I have?
1 minute.
Okay. Well, unregistered marriage is what I wound up with as what I thought was the right solution, and I'll be eager to hear in the questions your feedback on any of this, because I'm still trying to improve these translations, and I am happy for suggestions. So I'll just conclude by saying that the conclusion I've come to over the course of this project is that to resolve the dilemma between foreignizing and domesticating requires constantly balancing between recognition of commonality and acceptance of diversity. Despite what the far-sighted Orientalist, who I've been satirizing throughout this presentation, might think, there is never a fundamental break between one legal context and another. They are each fundamentally a human context. And despite what the excessive domesticator might think, no legal system and no human society can be broken into pieces and rearranged to look exactly like another legal system or another human society, as though they were both made out of the same plastic Lego pieces. Commonality and diversity, then, are the heart of the dilemma between domesticating and foreignizing. But they are inevitable in everything that we do. And it is only by keeping them both in view that we can truly bring our translations into focus. Thank you.
Questions? Radford. Just a minute. It's not. It's. We'll get the other one.
Oh, it's this right here.
It's at the bottom.
Well, thank you very much, Thomas, for this thought-provoking sort of presentation. Actually, I have some sort of question and also a comment. Let me start with a comment. You did really truly talked about the foreignizing that most of the translators, particularly those who try to adapt the text or try to make it more clarified to the target reader, that they do transliterate or transcribe the term and then add what we call definition by or description by definition and explanation. It's just, my addition is that sometimes this is not allowed in the body of the target text, particularly if the target text is a translation of a contract or an official agreement, etc. So what the translator actually does usually in this case is to make this exegetic translation or this translation by addition either as a footnote or as an endnote or as notes, just following one another. Another new trend that actually some translators have resorted to in the last couple of years is to write a commentary or analysis on the whole target text, in which they explore and analyze the sort of translation difficulties or translation problems that they've been encountering during the translation process, and the sort of techniques and strategic decisions they've actually adopted, and why they've adopted decision A rather than decision B. So this is the comment. For the question, I just would like to question الزواج العرفي. I'm not sure actually, because this is spreading, I think, over a couple of Arab countries. But as far as my knowledge goes, and please correct me if I'm wrong, this marriage has got a specific period of time. Is that right?
I don't know. That didn't come up in these decisions.
Yes, because as far as my knowledge goes, he marries a lady for a couple of time, for a couple of I don't know, weeks or months, whatever. Sorry?
That's not allowed.
المتعة?
This is al-mut'a? Right. No, misyar actually is legalized because it has no specific period of time. The only difference between misyar and the traditional one is that the lady actually compromises some of her rights. So she would accept that she actually needs the husband in the morning, so that he doesn't need to sleep with her at night. This is as far as my knowledge goes. So, but there is no time limitation. So al-mut'a in this case is the one which has got a specific time. Is that right?
Yeah, but al-urfi doesn't have a specific.
Doesn't have. Yeah. Because I was going to suggest actually a term for but probably this is for al-mut'a, if we call it probably.
Well, I might run into that later, so I'm happy to get the suggestion now.
Okay. Okay, thank you.
What would you recommend for mut'a?
For mut'a, I would say time-restricted marriage.
Okay. I'll put that in my bag of tricks.
Yes. Thank you.
I object. I think we should underline the fact that it's mut'a.
Okay, we'll have Zakia first and then Rana. Maybe could we have both of you, Zakia and then Rana?
Just this reminds me of translating from English into Arabic, the term partner.
Oh.
Yeah, so when you translate partner, so two people living together, having a family, but without a marriage contract. My students translated it sharik, because partner is a sharik. And then they added hayat, sharik hayat. But sharik hayat is husband. So, any suggestions?
Yeah, I think this is why, because the students tend to, or we ask the students to go to the United Nations website where they find the database for terminology like this.
No,
and
they invented it.
This is what has been introduced by the United Nations, so that the use of the word sharik for same partnership is same.
Sharik without hayat.
Sharik only. It is borrowed from business terminology, and it continues to be used. So,
Rana. Rana.
Thank you for the translation you come up with for this problematic term. I have a question which is somehow relevant. Do you think that domestication could be invoked in the case of translating terms which are loaded with cultural sensitivities? For example, the term riba, which is sometimes translated as usury, but in English, usury means that charging an interest rate which is too high. So still, it does not reflect this concept is related to the Islamic background, or that in Islam, charging an interest is actually religiously forbidden. So usually does not really cover all of the cultural background of the term.
That's a great question. I think it exemplifies the two worlds of law and language crashing together, because from a legal standpoint, there could be one term in two different jurisdictions defined differently. So it might, theoretically, there could be some country or some state in the United States that outlaws usury and defines it as interest over 15%. And another state that says, well, no, we outlaw usury, but it's interest that's over 50%, or some larger. So there is diversity and multiplicity among legal systems, even when they're using the identical terminology without any translation. And then when you're crashing in the legal issue, or I'm sorry, the linguistic issue of, well, is it riba? Is it usury? Is it interest? Is it gain? Is it, what word should we come up with? What's that? Lending with interest.
Savage has suggested, actually, she gave one of the very sort of valid solutions in this case. She suggested what we call translation couplet.
Oh.
So you would transliterate the term. So you would riba, write it as in R-I-B-A, and then you put usury. You would put usury because this is really the term which is often used when it comes to riba. And then the last thing, you would actually explain what is meant by riba here, according to the text, according to the translation situation.
I like that idea of the translation couplet. It feels to me like that might be a lot of us are rebelling against the constraints of translation, which force us to create one product and say this is the answer, even when we know that we have multiple audiences that we have to speak to, or that the same term could have different meanings in different jurisdictions. Really, there's more than one answer, and translating with just one word is limiting, and something is always lost in translation. The translation couplet seems like a creative way to break out of those fetters and find a way to maintain all the information that is in our head as translators, but which we tragically aren't able to totally transmit to the new audience.
So Hanem and Rana had comments, but could you please keep them? No, you don't anymore? Okay, so just Hanem.
I think my comment, if you just mentioned it now, I was going to mention that we don't have a choice between this domestication and colonization from what you have said as such, but correct me if I'm wrong, but I think it goes back again to what we have been talking about in terms of the function of the text while we are translating it, who is receiving it. This is a little comment I think I wanted to comment on.
Yeah.
Right? But also I wanted to again go back to the question of what we are expecting the translators to do. Because in the literature I have read so far in legal translation is that we don't ask them to really try to interpret or try to get into to dig for the function of the term in both languages as such. They try to get it if they can, but if not, they should leave the interpretation of this term to the court, which knows the criteria for disentangling or uncovering this term, if you see what I mean. So if we translate riba as usury or even zawajawati, I think the judge or the court in the private culture will always know what it means in this culture, if it's what they mean or in the source culture. So I think here we are asking the translator too much.
Maybe. The solution of whether to be domesticating or foreignizing at any given moment, probably, I guess going back to the analogy of the lens, you need to set up the lens at different distances depending on what you're looking at. So, focusing a camera lens on this glass of water right in front of me is going to be at a different distance from something that's 100 meters away. And maybe with each concept and each phrase, depending on the unique challenges of that idea, you're going to have to make different choices in each situation.
Could you join me in thanking Tom? And Professor Rafat, could you come?
They usually sit up. I mean, unless they want to use PowerPoint. So there's a chair behind you.
Okay.
I'll just ask you to come a bit closer to the so that we have.
Is there a mic?
Yeah.
And I'll tap on your shoulder when it's 5 minutes.
Okay. Shall I?
Professor Rafat Al-Wazna from King Abdulaziz University is going to talk to us about the syntactic features of Islamic legal texts and their implications for translation.
Thank you very much, Dr. Nancy. Actually, before I start, من لا يشكر الناس لا يشكر الله. So, many thanks to Aga Khan University, particularly the Center for the Study of Muslim Civilization, for this lovely conference. Special thanks are due to Dr. Nancy and to Professor Gianluca, who has invited me actually to speak in this fascinating conference. So many thanks to all of you, men. Right, so syntactic features of Islamic legal text and their implications for translation. I'll try to be as brief as possible. I will first give some sort of overview on legal language, then I'll proceed to mention some of the syntactic features of English legal texts, and then some certain features, syntactic features of Islamic legal text. Then I will quote a text from a traditional Islamic manuscript for you to see the sort of features we will be talking about, and then a translation of that text into English so that we can actually recognize the sort of translation implications resulting from translating an Islamic text into legal English, and then the conclusion. Right, so legal language is viewed as a technical language which is considered an adjunct of typical and ordinary language. Cotton, 1963, holds the view that technical as well as ordinary languages have the same syntactic rules but differ in terms of lexicon. Cotton, 1963, Morrison, 1989, and Chowa, 1993, all regard legal language as a technical language. Chowa, 1993, believes that legal language is often utilized in a context which assigns specific legal meanings to legal terms different from those they convey in non-legal context. Abu Ghazal, 1996, presents a variety of syntactic and semantic problems in the translation of legal text from English into Arabic through conducting an analytical study of certain translations carried out by certain postgraduate students. The main objectives behind the said study is to generally explore the type of linguistic problems often confronting by the translator when embarking upon any translation project. Bentham, 1782, proposes an empiricist theory addressing the meaning of lexicon, which advocates his legal theory as well as his utilitarianism. He intends from his legal theory to avoid what he views as myths of natural duties and rights which are not grounded in sense. He considers linguistic acts empirical phenomena an important part of his legal theory. He founds his legal positivism on his claims concerning the use and meaning of lexicon. He disagrees with the views of natural law theorists who haven't accorded special importance to language. Philosophy of language as ipso facto had no role to play in the explanation of the natural framework of law. On the contrary, Bentham, 1782, relies on the sensible phenomenon of a comprehensible, perceptible, and linguistic act to fulfill his function and serve his purpose, which lies in extending the natural framework of a law, drawing on empirical phenomena. Hart, 1994, throws issues that serve as the main interest of a number of legal philosophers, and at the same time borrows Austin's approach, which resides in using sharpened awareness of words to sharpen our perception of the phenomena. Such method identifies and outlines the backgrounds of two thorny issues which reside in the normativity of law and language as well as semantic sting. Hart's observation on language use in legal setting establishes the foundation of an innovative method for the challenge of the interpretation of the normative nature of law, as well as the evident problem in the legal theory stated in the imprecise explanation of the normative language put forward by Bentham, 1782. Hart is considered among those who believe that legal language as a technical language is different from ordinary language. He believes that legal terms impart on the meanings of neighboring words and possess their legal meaning only within a particular legal system and through specific legal rules and provisions. Conversely, Dworkin's 1986 views are repugnant to Hart's 1994 theory of law. This can clearly be shown in the notion that Hart's method of legal philosophy is controlled by his method of lexical items, and that he mistakenly believes that lawyers should adhere to specific linguistic measures in the process of judging legal propositions. This is the argument made by Dworkin, 1986, on semantic sting. It is a claim concerning the philosophy of language which has successfully given rise to further debate and discussion within the realm of law. Milenkoff, 1963, examines the history of the legal language and investigates the nature of the language of the law. He plays a crucial role in introducing the language of the law into practice. Based on the foregoing, it can be said that legal language is deemed a technical language which is imbued with legal terms that affect the meanings of their neighboring words and possess their legal meanings within a particular legal system and through specific legal provisions. Legal texts can also be viewed as texts that comprise a great amount of linguistic conservation found in written rules such as charters, constitutions, and so on. Legal translation can serve one of the following purposes. It can be for informative purposes, where the translator is required to transfer the intended legal meaning only of the source text into the receptor language. However, if the purpose for legal translation is to apply it to the country of the target reader, the translator is required to transfer the intended legal meaning as well as the intended legal effect of the source text into the target language. There are, however, peculiar syntactic features of English legal texts. Among these are the little use of punctuation system, nominalization, passivization, use of modal verbs, as Dr. Hanim Farhati talked about this morning, use of complex structures, adopting impersonal and formal style with heavy use of conditions, qualifications, and exceptions, a use of negation and multiple negations, use of adverbials, as well as repetition of certain terms. The legal English sentence is lengthy, complex, and convoluted, with a number of embedded clauses that would separate the subject from the main verb. Also, there are complex and lengthy phrases arising from nominal post-modification. Islamic legal texts have almost the same syntactic features as those possessed by English legal texts, albeit with some variation. Islamic legal texts make use of long chunks of sentences with a heavy load of detail. They hardly employ punctuation markers, but exploit a considerable number of nominalized forms. Passivization. Islamic legal texts make use also of passivization, although they generally prefer to adopt active voice to passive voice. Participles are also used in Islamic legal texts in the forms of both active as well as passive participles. Islamic legal texts make use of the Arabic cohesive device A as a syntactic tool to connect prenominal references placed before it to the reference thereof placed or located thereafter. Okay, now this is an excerpt taken from Al-Bahuti, 1636, volume 2, page 143, within the context of sale conditions, quoted for the sake of presenting certain syntactic features of Islamic legal text. I will try to recite it a bit, slowly so that you can, realize the syntactic features. الشرط الرابع أن يكون المبيع مملوكا له أي البائع وكذلك الثمن ملكا تاما حتى الأسير في أرض العدو إذا باع ملكه عليه أو أن يكون البائع مأذونا له فيه أي البيع من مالكه أو من الشارع كالوكيل وولي الصغير ونحوه وناظر الوقف عند عقد البيع ولو ظن أي المالك والمأذون له عدمهما أي الملك والإذن في البيع كأن باع ما ورثه غير عالم بانتقاله إليه أو وكل في بيعه ولم يعلم فباعه لأن الاعتبار في المعاملات بما في نفس الأمر لا بما في ظن المكلف فلا يصح تصرف فضولي ببيع أو شراء أو غيرهما وإن أجيز تصرفه بعد وقوعه إلا إن اشترى الفضولي في ذمته ونوى الشراء لشخص لم يسمه فيصح سواء أنقذ الثمن من مال الغير أم لا. It's complicated, isn't it? Okay, a translation of this into English can read as follows. The fourth condition is that the sold property shall be wholly owned by the seller, and the same applies to the consideration, even if the buyer is held captive in the land of the enemy. If the seller is not the owner, he shall be authorized to sell the property either by the owner or by the lawgiver, such as the authorized agent, the guardian of a minor, the endowment administrator during the conclusion of the sale or the like. Even if the owner or the authorized person assumes the non-existence of his ownership or his authorization to sell the property, for instance, if he sells a property he has inherited without knowing that such property has been transferred to him by way of inheritance, or authorizes a person to sell it without knowing of the inheritance, and then the authorized person has sold it, the sale shall be valid. This is because the attention in transactions shall be paid to the matter itself, not to the assumption of the legally responsible person. Therefore, it's not valid that an unauthorized person disposes of a property by way of sale, purchase, or another way, even if his disposal has been accepted after it had occurred, with the exception that if the unauthorized person buys in his liability or intends to buy for an anonymous person, the purchase shall be valid whether he pays the price from the money of others or not. The present paper argues, I'm in the conclusion now. The present paper argues that the syntactic features of Islamic legal text succinctly lie in having lengthy sentences with minimal use of punctuation system. Moreover, nominalization, passivization, participles, the use of the Arabic cohesive device as a syntactic tool to connect pronouns to their reference are all syntactic features of Islamic legal text that also characterize English legal text, but with some variation and with the exception of the last feature. The present paper also claims that when rendering an Islamic legal text, however small, into legal English, certain translation implications emerge. Such implications reside crucially in the necessity of having a sentence break when rendering a text from legal Arabic into legal English due to the difference in length between the two legal languages in question. What is more, the use of punctuation system, nominalization, pacification, and past participles are all employed in English legal text more than in Islamic legal text. With regard to the use of the active participle, there is no considerable difference in number between Islamic legal text and English legal text according to the sample used in the current research. The use of the Arabic cohesive device A in Islamic legal text is omitted when rendering such text into legal English. The current research has been conducted on a small sample. An investigation on bigger samples is needed to arrive at more comprehensive and plausible results. Thank you very much. Okay, thank you very much.
Any questions?
Thank you, Rafael. I was wondering then if then there is this, I mean, you seem to also suggest that there's a need to mark the text as somehow legal. So throwing in the shell then performs that function. So it's not just, the translation of the text, but also marking it as legal so that it can be perceived as one such text. Right? So that's a question on marking the text, irrespective of the content. And then the other one is since you pointed us to A, there were, of course, a few cases in the text, right, in which A,
A, yes.
Yeah. And then, of course, I couldn't remember all of them. But in your translation, in one case, you translated in such as. In the other, so I wonder if you could actually list this for us that couldn't follow
right
the entire sequence of A.
Right. No, actually, what happened is that the translation of A has completely been omitted actually in the legal text, because one of the presenters before me, I can't remember who, it is said that English needs less discourse markers because of the quality of the punctuation system in English, and this is unlikely to be the case in Arabic. That's why we do use different discourse markers to link different parts of speech together. And to be honest, I was very surprised when I found this in different texts of traditional Islamic legal text. And I did some sort of research trying to find out if there is a meaning. And then I found out that it is also located between, a pronominal reference and a referent, as it is a syntactic tool to connect between them. So I think it's used here as a cohesive device, plus that it is a syntactic tool. It is a cohesive device to link the pronoun to its referent. And of course, and by the way, the translation I actually read to you is not mine. I found different translations for this text, and I tried to take probably the best one. But all the translations that I've actually come across, they had no any equivalence for A.
Interesting. Yes. Okay, well, if you can always come back and if you think of any other questions, but otherwise we'll call this panel to a close and thank our speaker again. So, as you might have noticed, we are half an hour ahead of schedule. Amr Shakalani did send his apologies that he could not come. This means, could I ask you please to come back to this room at 3 p.m.?